There is an old saying that if you ever find yourself in a hole, you cannot dig yourself out of a hole, so stop digging. And, on June 21st, the day after the primary elections for Arlington Democrats, the Federal District Court in the District of Columbia had issued what is called a minute order, denying the plaintiff's motion for issuance of a summons and requesting service of the summons and complaint upon the defendants by the United States Marshals. The named defendants in the matter were Meta Platforms Incorporated, formerly Facebook Incorporated, and the Office of Management and Budget, or OMB, the office that is responsible for handling requests for documents submitted under the Freedom of Information Act, or FOIA, to the White House, and, in this matter, the two defendants had become joined in an amended complaint in another action commenced on July 7, 2021, simply seeking to compel the White House to respond to a FOIA request, which any federal agency is required to do. However, things became complicated when, after the original complaint had been filed, the White House began to crack down on problematic accounts, including the account of Robert F. Kennedy, Jr., an outspoken anti-vaccine advocate, on Facebook, in a press conference held on July 15, 2021, and the requester, Major Mike Webb's Facebook account was disabled for security reasons, raising a reasonable inference of retaliation, having occurred within a reasonable time after the original complaint had been filed in federal court, a complaint that had sought to overturn the decision of the government to proceed with mandating the COVID-19 countermeasures, popularly described as the COVID-19 vaccines. The plaintiff in the action was Major Mike Webb, who was, at the time, a candidate in an election for the Arlington Public School Board against Arlington Democrat, Mary Cadra, who had formerly been a high school science teacher, running in an election year in which one of the primary issues had been the safe reopening of public schools and mandatory vaccines, making the loss of a social media account a devastating blow for a political candidate, especially one identified as far away as Seattle in the Progressive Voters Guide as having been against the government response to the public health crisis, which would certainly resonate as a negative factor for residents in a community with the most government scientists, and where Arlington Democrats have been described by the Washington Post as holding all of the strings of power. However, the most serious allegation that Major Mike Webb had raised against Facebook had been their decision to block his access to a place of worship, especially during a lethal pandemic, in which in-person worship had been discouraged, especially for the unvaccinated, and when Virginia residents were being given the message from Governor Ralph Northam, a medical doctor, that churches were hotbeds of infection, and had been encouraged to stay home. As Dr. Northam had stated, worship outside or worship online is still worship, and, explaining, "This year, we need to think about what is truly the most important thing. Is it the worship or the building? For me, God is wherever you are. You don't have to sit in the church pew for God to hear your prayers." Governor Northam had made these remarks in December 2020, when he had conceded that he could not legally limit in-person worship ceremonies, noting that the recent Supreme Court decision against the state of New York prevented him from doing that. Yet still, he blamed churches for contributing to the spread of the virus, noting that some houses of worship were not social distancing or wearing masks. He had claimed that he had heard reports. And, without citing to any specific examples, quite frankly we know that a lot of the spread is coming from this, he said. He urged faith leaders to lead the way and set an example for their communities. However, Governor Northam's admission that he had abused and exceeded his authority in restrictions against churches had, unbeknownst to most religious faith leaders, exposed the now former Virginia governor to liability for unlawful blocking the entrances to places of worship, a violation of the Freedom of Access to Clinic Entrances Act, which had been introduced by Senator Chuck Schumer and signed into law by President Bill Clinton in 1994, primarily to provide protection to abortion facilities, and which would provide the same protection to the entrances of places of worship, and entitling those aggrieved to at least a settlement against the defendant for $5,000 per instance in which their access to a place of worship had been blocked, which would include regularly weekly devotional services, as well as even Bible study. And, as the former Virginia governor, Dr. Northam, had urged faith leaders, Major Mike Webb decided to think about what is truly the most important thing, when his access to what had been designated as a safe place of worship had been unlawfully blocked, and, more concerningly, in what had amounted to a collusion between the White House and Facebook, a conspiracy, under color of law, to violate fundamental civil rights, i.e., the First Amendment rights to the free exercise of religion. If worship outside or worship online is still worship, certainly no worship at all would be the greatest infringement and derogation of a constitutional right, forming the basis of Major Mike Webb's complaint against the social media giant. However, with the aid of the federal court in Richmond, acting essentially as a gatekeeper, protecting the defendants, at least until now, since July 2021, Facebook, now Meta Platforms Incorporated, has yet to enter an appearance in the action, has not filed any pleadings or offered any public statements, at least until now. However, after the minute order issued on June 21, quashing Major Mike Webb's motion to enlist the aid of the U.S. Marshal to serve the complaint and summons on both defendants, he has been compelled to retain the services of a commercial process server provider, to bring the social media giant, Meta Platforms Incorporated, under the jurisdiction of the federal judiciary, for a right to due process, an opportunity to be heard in a meaningful way, in a day in court, which is the process that is due. Like the federal racketeering statute, the predicate offenses in the FACE Act are at their essence criminal violations of law, which, if repeated, amount to felonious conduct, and which would require proof beyond a reasonable doubt, arguments that now attorneys retained by Mark Zuckerberg and Meta Platforms Incorporated will now have to address, after over 2 years of being fugitives of justice, exercising a right to remain silent to avoid self-incrimination. And, certainly damaging to any claim of innocence for Facebook is their persistent pattern of evasion for what is now going on 2 years. And, under U.S. v. Pangito, decided in 1990 by the Third Circuit Court of Appeals, evidence of flight may be used to infer consciousness of guilt. In summary, attorneys for Facebook, or Meta Platforms Incorporated, must, to the satisfaction of the court, present affirmative defenses that explain how their actions did not unlawfully block Major Mike Webb's access to a place of worship, a designated safe place of worship, during what has been repeatedly described as a lethal pandemic involving a highly contagious virus, most adversely affecting places of worship, where Governor Northam, a medical doctor, had claimed that he had heard reports that these churches had been hotbeds of infection. Facebook, or Meta Platforms Incorporated, must, to the satisfaction of the court, present affirmative defenses that defeat a claim that, beyond a reasonable doubt, they had not infringed upon Major Mike Webb's rights under the Free Exercise Clause, which gives all citizens free access to places of worship, and, during what has been described by former Virginia State Attorney General Mark Herring as an unprecedented, once-in-a-lifetime pandemic, during which he had formerly claimed successfully to Virginia state courts, that the scope of a court's review must be limited to a determination of whether the executive's actions were taken in good faith and whether there is some factual basis for the governor's decision that the restrictions he imposed were necessary to maintain order, an argument that, in December 2020, Dr. Northam had admitted was not so. And, further, Facebook, or Meta Platforms Incorporated, must, to the satisfaction of the court, present affirmative defenses that defeat a claim that, beyond a reasonable doubt, they had not, while acting as an agent of the White House in engaging in censorship of what had been described as problematic accounts, violated the Establishment Clause, which provides that the government shall make no law in the establishment of religion, which courts have construed to include any regulation that is essentially an anti-religious law. Federal courts have held that the loss of First Amendment freedoms, for even minimal periods of time, unquestionably constitutes irreparable injury, a first prong in establishing a prima facie case for injunctive relief. And, yet another challenge for attorneys to be retained by Facebook, now Meta Platforms Incorporated. They will have to overcome what appears to be in evidence an adverse action that had occurred within a reasonable time after Major Mike Webb had commenced litigation against the White House for their failure to respond to a request for documents under the Freedom of Information Act. And, articulating what has been described as the time/decision rule, in Reed v. MSPB, the Federal Circuit Court of Appeals, in 2007, had held that a complainant need not demonstrate the existence of a retaliatory motive to establish that the protected activity was a contributing factor, essentially a burden-shifting mechanism that shifts the burden of proving that the actions were not retaliatory upon the defendant, Facebook, now Meta Platforms Incorporated. And, once the knowledge/timing test has been met, an administrative judge must find that the appellant has shown that the protected activity was a contributing factor, even if, after a complete analysis of all of the evidence, a reasonable fact-finder could not conclude that the appellant's protected activity was a contributing factor, as stated in Schnell v. Department of the Army, in 2010. All of this will be far more difficult since, under Pangitor, evidence of flight may be used to infer consciousness of guilt, and now attorneys for Facebook shall have the opportunity to confront their accusers, or exercise a right to remain silent, to avoid further self-incrimination. Once the complaint and summons are served, after what has now been over 2 years, attorneys for Facebook, now Meta Platforms Incorporated, will present arguments in what had been what attorneys describe as a case of first impression, because no person, before Major Mike Webb, has ever brought a challenge under the FACE Act for the unlawful blocking of access to a place of worship. A first test for this provision of the law that had since its inception in 1994 been almost 100% successful in protecting the rights of those persons seeking access to abortion, which is not even a fundamental right that had been guaranteed in the Bill of Rights, like the freedom of religion, a case that neither Robert F. Kennedy, nor any of the misinformation dozen, the 12 people who had been identified as being responsible for the majority of COVID-19 disinformation shared online, accounting for over 65% of the posts, by the Center for Countering Digital Hate, CCDH, have raised. It is of significance that Major Mike Webb's account on Facebook was not disabled for spreading medical misinformation, but rather, expressly for security reasons, as a designated whistleblower, identified by the federal courts, having essentially served formerly in the U.S. Army as a biological warfare planner, who had been offered a job in a top-secret billet for an officially disavowed or expired mission 4 years before the emergence of a novel coronavirus, now attributed to more fatalities worldwide than Adolf Hitler during the Holocaust, in half the time, actions that have spawned additional litigation, still pending before the Merit Systems Protections Board and federal courts, to include the United States Supreme Court. In a former life, 3 decades ago, Major Mike Webb had served as the operations officer for all Army strategic counterintelligence in the continental United States, the most junior commissioned officer to have ever served in that capacity, and, therefore, could be certified as an expert witness on a matter in which the Supreme Court, in Jacobson v. Massachusetts, a smallpox vaccine case, decided in 1905, had determined that the only competent evidence that could be presented to the court to prove these propositions was the testimony of experts, giving their opinions. And, as stated by the U.S. Supreme Court in Monitor Patriot Company v. Roy, in 1971, with regard to a political campaign for a candidate, it can hardly be doubted that the constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office. But, at least, for now, that voice from Major Mike Webb has been silenced, and awaits the arguments to be presented by attorneys from Facebook, now Meta Platforms Incorporated, in a true test of the right to free speech, and also the freedom of religion. Democracy is truly at stake. That is the news for now in Arlington, and we shall keep you posted on this developing story.
This message was approved by Major Mike Webb. Honest.